Good morning, everyone. Good morning. I'm just going to wait for you guys to tune in. Um, good morning, good morning, good morning, Instagram. Good morning, YouTube. If this is your first time, welcome. Good morning, Wagner. You could apply for 2023. I don't know what the question is. Good morning, Prince, Hancho, Geraldo. Good morning, everyone. Good morning. Ugo, Jimmy, thank you so much. I appreciate that. Felix, good morning. For those of you tuning in for the first time, welcome. My name is Aisha Chidoe. I'm an immigration attorney in Atlanta, Georgia. I represent clients all over the United States with their family immigration matters, humanitarian cases. We also handle removals and detention work. So if you have a marriage-based case, a family-based case, consular processing, fiancé visas, removal of conditions, waivers, naturalizations, pretty much, all of that. We also handle VAWA case, trafficking cases, U visa cases, which are for victims of a serious crime, deportation defense cases, and some bond cases. If you want to schedule a consultation, you can call the office at 407-995-6567. I'm going to pin my number here and WhatsApp as well on Instagram. But if you are on Facebook or YouTube, you should see the number like scrolling through on the ticker. So you should be able to take it down. And as always, if you want more information, after the live, definitely comment yes. If you want to ask more questions that didn't get answered or you want a confidential consult, comment yes. Or if you want to learn more about immigration and what options are available to you, always comment yes during the live, or after the live, and then we can reach out to you after the live because, again, during lives, these questions are going on different platforms at the same time. So sometimes I cannot see every question, every comment that's made. So I just move as I see them. So today I wanted to talk about, and I will get to some of your questions, but today I just wanted to talk specifically about marriage-based cases, especially when we have people who have filed multiple times. So I don't know, it seems that there is this misconception or presumption that, okay, I filed for a marriage-based case with somebody else and, my case was denied. And so therefore, I'm just going to get married again and file again. It is very important that you understand that anytime you submit an immigration application, every application that you have ever put forth to the United States is on the table for review, starting from the time you applied for a B1, B2 visas. B1, B2, meaning a tourist visa, or any other kind of visa that you applied for. USCIS is going to be looking at all of your information, all of your history. So if they are going as far as a B1, B2 visa, somehow there are people who believe that, well, that marriage didn't work out, we didn't have enough, evidence, and so the case was denied, or we just never responded to the RFE. So now I have a child with this person, so I'm just going to move on with this application. One of the things you guys need to understand is this. If you filed a previous case with a spouse and USCIS didn't approve that, when you are filing with the new spouse, you must be prepared to present evidence from the first spouse that you filed with. So whether or not that marriage was 2 years ago, 1 year ago, 3 years ago, USCIS is going to be looking to understand why did that application not get approved? And if that application didn't get approved because there was not enough evidence to prove good faith marriage. You see how I didn't say marriage fraud? There was not enough evidence to prove good faith marriage. They can still come back and ask you to provide evidence that that marriage was in fact genuine. So sometimes, people assume they have to put a tool for, see there and specifically stamp it and say marriage fraud. Sometimes that's not what they say. Sometimes they could use the phrase, this marriage was to circumvent the immigration process. There's not enough good faith evidence. So it's not to say that when you submit your application, you're submitting a dual application of proving good faith marriage of the previous marriage and your current marriage, but it is important that you have documentation of your previous marriage. You have proof that that marriage is genuine. And if you don't have physical evidence of like a lot of things that you can use to support good faith marriage, you have to be prepared to explain why you don't have that evidence. So going into a new marriage is fine and good, and having more evidence with a person, but make sure that you're also able to overcome the presumption that the first application that you put was one for a genuine marriage. Because I see this a lot. People will come to us and say, oh, I found a marriage-based case with my husband, we have a child together, whatever it is, and, everything was good. We're prepped, and, we went to USCIS, and USCIS was like, well, I don't really want to talk about this marriage. I want to talk about your first submission, right? And so that's why I'm telling you guys this. A new marriage doesn't cure a defective previous marriage application. Gathering evidence to prepare and to support your case of that previous application is what cures a defective previous application. And a lot of times, I see people try to do this themselves, because most of the examples I'm talking about are generally people who started the applications themselves. And they will tell you they started the application themselves, they put it in themselves, they went to their whatever, interview themselves, and then, they got like an RFE or a notice of intent to deny, and then that's at the point where they decide to retain an attorney. A lot of times, so much damage has been done, by then. That is why it is important to put in a proper application the first time. It is important to consult with an attorney the first time. It is important to go through your evidence the first time. People submitting bank statements, for instance. You say you live in the same place. You submit bank statements where one person lives in Alaska and the other person is living in New Jersey without any explanation whatsoever as to why all these transactions are showing one state and the other state when you claim you live together. Right? People put in evidence that don't really make sense, or text messages where it's very difficult to corroborate with no date stamp, no time stamp, no screenshot of the number or the upper heading, so that USCIS can know where this text messages are coming from. So it's really, really important, guys, that you don't just use a new marriage and apply as a copy and like a covering, like, oh, let me just do this one and I'm going to get it through this person because a marriage-based case is quicker. You file based on a legitimate marriage, number one, and number two, because you have all the supporting evidence to prove that all the marriages that you've entered into are good faith, and that you can submit that to USCIS. So it's just a forewarning, because I'm seeing that a lot, where these noids that people are coming for, or denials where they want us to file an appeal, are based on cases that were filed previously, not with their current spouse, that were denied, and therefore they don't have any records or any contacts or any communication with that person. So if you are someone going through that right now, like meaning you're going through a situation where you're in your first marriage and you're having issues with that person, and you're on the verge of divorce, make sure you have evidence. Make sure you have evidence that this is a good faith marriage, because regardless of what immigration route that you go, you want to be able to provide that should USCIS ask you for that. All right, guys. Victor Adosia says, good morning, first time here. Good morning, welcome. Hi, Susan and Ira on Facebook. Good morning, guys, welcome. All right. Someone is asking how much are for consultations. We charge $150 for consultations. Again, if you want to schedule consultation, call us 407-995-6567. It's in the ticker, scrolling through the ticker, and I pinned it. And if I am not able to get to your question, comment yes, and we'll reach out to you afterwards. Someone is asking, I was in a relationship for 11 months and we decided to marry. It's been 1.5 months and I'm mentally depressed and abused by her. Can I apply for VAWA? I don't have any other case before. Well, first of all, in order to be eligible for VAWA, you need to be screened for VAWA to make sure that you meet the elements. So abuse is not the only element of VAWA. There are many elements to a VAWA case. That's number one. And also, we have to also understand, what are you stating constitutes abuse, in your marriage? Because there are certain times where somebody might say, for instance, my spouse cheated on me, right? And therefore I want to file a VAWA application. Your spouse cheating on you is terrible. It's truly terrible. But USCIS has always taken the position that one act of infidelity is not enough to prove extreme cruelty and abuse. When you're looking at submitting a VAWA application, USCIS is looking at the totality of things that have happened. For instance, using the same cheating analogy, have there been multiple cheatings happening in your marriage where your spouse has touted it and basically been like, yeah, I'm doing all of this. What are you going to do about it? Or putting you at risk of an STD or an STI or, a disease or, basically putting you in harm's way. So, that would be an example of how you look at a totality, So they're looking at different things that when you combine them together result in extreme cruelty. And the only way to be able to tell you whether or not you're eligible to submit a VAWA application is to consult with an attorney, and then an attorney can go through the elements of VAWA to make sure that you're eligible for it. Let's see, what other questions do I have? Someone says, I have a VAWA approved since September 2024, and I have a 485 still pending. We're actually starting to see 485 interviews for some of those cases, 2024 approvals and early 2025. So hopefully you'll get one very soon. I did my immigration medical, but I haven't submitted it. How long do I have until the deadline for that medical? It's going to depend on when you did your medical, because right now, if you do the medical for a specific application that is pending right now, and you haven't submitted it, it typically doesn't expire, but it depends on the exact date that you did it, because I don't know when you did your medical. So it would depend on when the medical was done. Suffice to say, anything done this year, for instance, will be good unless the rules change. For most people submitting applications from 2025, you would know that you needed to have submitted your medical at the same time. People who submitted prior to that timeline typically did not, it wasn't a requirement. And, that was when people had the COVID requirement, like the COVID vaccine requirement. And some people chose not to do COVID vaccine, and we're waiting to see if the COVID vaccine will be removed or whatever reason, because then medicals used to expire. So for those people, generally, what you want to do is when you are scheduled for your interview, if you didn't submit your original medical, or you submitted a medical prior to 2025, before the interview, you want to confirm the interview, the medical edition that was submitted. And depending on the medical edition that was submitted, what you would need would be you need to get a new medical done based on the new requirements. So everything just depends on the timeline of your submission. When are you scheduled for an interview? Because if you submitted your file before 2025 and you never submitted a medical, you can't just arbitrarily send a medical exam, because it's going to get lost. You either wait for a request for additional evidence where they will request the medical, or an updated copy, or you take it with you to the interview. Okay. All right. Let's see what else. Good morning, Sunnison and Jesse from New York. Pat Spraxton, good morning. Last thing I heard was there was corruption in Louisiana. I'm not sure if you're asking me a question or you're just kind of like giving me some comments. What is the downside of filing with an NGO immigration lawyer and paying only USCIS fees versus filing with paid attorneys? I mean, I can tell you, you should know, like, I can't speak for any organization, because I don't work with them. So I don't know. I can only speak for myself. I can't even speak for any other paid attorney. People hire who they believe are capable of doing the work, whether that's a paid attorney or nonprofit attorney, whoever you feel is capable of doing the work. It's the same thing where some people will choose to go with a criminal defense attorney instead of a public defender, right? Because maybe they feel that a criminal defense attorney is much more zealous in the pursuit of making sure that their case is successful because, when you are a nonprofit, you're essentially just kind of like checking the box. But again, I don't want to say that because I've never worked with any nonprofit, because obviously I'm an attorney, so I'm not seeking immigration assistance. So the best thing for you would be to ask people who have used a nonprofit organization and maybe a paid attorney to see what the difference is, right? Just make sure that whoever you go with, you will, they are able to do the job that you need them to do. Um, my marriage has gone past 2 years since May 3rd. Do you think I'll be hearing from USCIS soon about a green card decision? Well, without knowing exactly where your case is, I can't answer. Have you had an interview? When did you have your interview? Have you not had an interview? Did you get a request for evidence? So there are many variables that without knowing, it's hard to give you an answer. What is the next thing after a denial of an I-485 due to the withdrawal from a spouse? If your spouse withdraws right down in 2026 and your I-485 was denied, typically at some point, USCIS will issue you a notice to appear in front of an immigration judge. At that time, you'll have the opportunity to plead whatever you might be eligible for. Or if you already have filed if there is something else that you're eligible for, you can then file for that, and the judge might either continue. Continue means put the case on hold to allow that to finish, or the judge might ask you to finish it in court. So that's typically what would happen. Okay. Someone says, what is it normal getting a second biometric after initial one for a valid case? A friend of mine, this is for a friend of mine. Yes, it is actually. We are seeing that a lot where somebody might get a biometrics for the work permit and travel permit, and the I-360, and then the 485, you would have a separate biometrics, I am curious, and I will find out more about this because, I like to see a trend of something. Like I've seen more recently where, like, let's say you filed for a case, your 485 biometrics are a little different. So I don't know if that's because the 485 is what gives you the green card, and that's what they're using the new FBI system to do. But definitely, it's not uncommon at all to get multiple biometrics. What you check to confirm this is if you look on the letter, the biometric letter, it would have the name of the form. You see generally that the forms are different, like they may be calling them for one on one and then one on the other. Now, if you're getting biometrics for the exact same form at the exact same time, then that's odd. That's odd. The other scenario where you might get like double biometrics is if your biometrics was like 4 years ago or something, and now the USCIS wants more recent ones where they will rerun it again. So those would be the categories. I'm on H-1B, and I'm in a relationship with a U.S. citizen, and it's been 4 months. We're planning to get married next month. Any recommendations about when and how to file my green card application? The most important thing is having a good faith marriage. So there's no when or how. Just have proof that your marriage is genuine. I cannot stress that enough. Like, that is the sole requirement of a marriage-based petition. People have date for a long time, people date for a short time, people, but the key is good faith marriage. Is this a genuine marriage? What evidence do you have to prove this is a genuine marriage? That is what USCIS is typically looking for. Okay. My friend paid $8,000 for a paralegal to do her I-485. It's been 15 months, still saying being processed marriage-based. Well, unfortunately, Bella Vita Fitness, I don't know how to answer the question. I don't know what your friend paid for or what was done. I can tell you the paralegal charges even more than us, that we're 20-year licensed attorneys for a marriage-based case. That said, I would suggest that your friend consult with an attorney so that they can look at their file and just to make sure everything is good. At least, as it stands, 15 months really, I wouldn't necessarily say it's a long time. It's longer than we like to see for a marriage-based case, but it depends on what has happened in the case. And this is where I say context matters a lot. Sometimes, somebody might have had more than one RFE. Somebody might have had, an RFE for an affidavit of support, meaning financial affidavit of support. They might have had an RFE for good faith marriage. They may have moved from one state to the other and updated the address and the files needed to move. So there are different variables, but without knowing these cases, my hair is like flying. Without knowing these cases personally, it's really hard to really say where it is. One thing that I forgot to mention earlier, I talked about if you were someone who filed a case before and then that case got denied, and you remarried somebody else again and you want to file, it is important that you do a FOIA. A FOIA is FOIA. It stands for Freedom of Information Act. Basically, that is where you request USCIS to give you your entire immigration file, your entire alien file. Looking at your entire alien file helps you to know and see what was initially submitted, and sometimes the decisions that were made with immigration if you're not sure. Now, a lot more recently, USCIS will do a lot of redacting based on who. So there used to be a time where you could order for your marriage-based case and you would get i.e. things on your I-130 or whatever it is. But because the I-130 is the petitioner, that's the U.S. citizen spouse, we see a lot more redacting of that application. And then instead, they may give you the good faith evidence and the 485 and any other submitted supportive documents, and maybe the officer's maybe notes or commentary on your actual application during the interview or review, just to see whatever it is. Are they recommending it for FDNS, which is the fraud department, or what it is? But it helps to kind of see what your file is, because it is shocking that there are so many people that say that they don't know what they don't have a copy of their immigration application, or they don't have any record. When you submit your case to the United States government, it is important for you to keep a copy of what you submit to the United States. This is just for due diligence purposes. Whether it doesn't matter what case type, it is important to keep and document these things, because should you ever need it, and especially in a case where you submit a FOIA and they're redacting. Redacting means blurring out. You have the actual copy of the file that was submitted, So you should be asking that to your, if your attorney doesn't provide it, you should be asking your attorney to provide that for you. If you're self-preparing your application, you should be making a full copy of the entire application packet. I can't imagine anyone trying to self-prepare, right, in this administration, but to each his own. If you do that, just have a copy of what it is that you are submitting. Okay. Okay. Eva Mary Chema says, I see some people from the 39 banned countries posting about getting immigration decisions. Has anything changed on those 39 countries? Pause. So you use banned and then you use pause. So I'm assuming you're talking about the 39 countries that had the initial pause here in the United States. Yes, we are seeing some decisions, albeit slow. They are coming slowly, but we are seeing some decisions on the preliminary application, i.e., the I-130 applications in a marriage-based case. We are seeing the approvals coming for those. And we are also seeing for fiancé visas like the I-129F coming. We haven't yet seen the 485 because, as you guys know, right now they are running fingerprints for every country, not just the 39 countries, every country and every application that was submitted before April 27th of 2026 for 485's naturalizations. So once they finish running those, they're going to start making decisions again on those cases. They claim that they are giving priority to those who have been scheduled for interviews or have had interviews. So we're waiting to see what happens with that. But yes, the I-130s, we are at least at the firm seeing them. They're still coming in trickles, but we are seeing those starting to come in for those case types. From a consulate standpoint, the consulate, you're dealing with two things. You're dealing with a ban and a pause. Since you specifically mentioned the 39 countries, if you're in one of the 39 countries outside of the United States, the ban is still in effect outside the United States. So for those ones, we're not yet seeing any approvals. So unless we see any approvals or a ban being lifted, I can't give you that information because we've not seen one. We do have a series coming up again. We're still waiting on one that we had, in March for some sort of decision, but nothing yet. So I can't really, give you that. Okay. Good morning. Do VAWA cases get interviewed? Yes. So since December 2020, not all, but some do. Since December of 2024, I think right before President Biden left, you will recall that they did make the announcement that some cases will be selected for interviews for your I-360 VAWA portion of your application. So they will interview you for your I-360 and your 485 at the same time. A lot of times, not all VAWA cases will get interviewed, but there are times when VAWA cases, the I-360 will get interviewed. I can't tell you who and who does not get interviewed, but we definitely see some people get interviewed. Okay. See, I'm seeing a lot of duplicate questions that I think I already answered. Is age difference a red flag? Yes, age difference is a red flag, but the question is how much age difference? If you and your spouse are like 2 years, 3 years, 4 years, 5 years apart, that's normal depending on what country you're from. For instance, I'm 5 years apart. My husband is 5 years older than me. Obviously we've been married 17 years this year, so we're obviously in a genuine marriage and we have 2 kids together. But when you start to talk about age difference in the double digits, what USCIS is typically going to look at is what is the country norm of where that person is from. Let me use like African countries, for instance, West Africans, right? Most West African men generally, it is not common for them to marry women who are older than them because of the whole mentality of, I want to be able to have a child with my spouse. If this person is much older than me, are they going to be able to have a child? Whatever, for whatever reason that they give. So if you have like a husband, for instance, that is 30, and the spouse, the female spouse, I'm just using this for example purposes, is like 50 years old. So you're looking at a 20-year age gap. It raises a red flag. But that in and of itself is not a reason to deny. So it raises a red flag to say, okay, this is not common for people from here. But Since it's not common, prove to us that this is a genuine marriage and not for immigration purposes. Everything always boils down to the same thing: proving good faith marriage. Prove your marriage is genuine. Don't just marry to marry, and so it's not worth it. And to submit an application, prove your marriage is genuine. If you say, you know what, love is love, she's 50 years older than me, she's 30 years older than me, but we love each other, just prove it. That's all you need to do. I still see a lot of questions, and I'm sorry I couldn't get to all your questions, but again, comment yes in the box, or once I save this live, comment yes, and send us a DM, and we'll try to schedule for a consultation with your own case, or try to answer if it's very quick. But I hope you guys have a good rest of your day, and I will talk to you guys later. I will be on live tomorrow. I got to check. I might be at USCIS tomorrow, but if I'm not on, you can check at 10 a.m. If I'm not at USCIS tomorrow, I'll be on live. I hope you guys have a great day. Talk to y'all later. Bye.